students, I am Tulika Banerjee. Today I bring you the next learning episode in BSc Forensic Science on behalf of the content writers Dr. G.S. Sodhi and Deepika Bhandari on an important unit of paper Crime in Society, that is Introduction to Courts at Various Levels, in which we will discuss about the various types of courts under criminal and civil law. Let us start our module with a look at what we are going to learn today. First is introduction, then types of courts and their powers such as metropolitan courts, district courts, family courts, labor courts and industrial tribunals. Then we have the tribunals and lastly the conclusion. So, dear students, let us begin with the introduction of this lecture. Indian judiciary is a single amalgamated system guardian of the fundamental rights of people in India. The duty of Indian judiciary is instructed in the Constitution of India. It balances the distribution of power between the state and the central government. Our judicial system is in an integrated manner. The apex court of Indian judiciary is the Supreme Court and it is the highest judicial tribunal. After the Supreme Court at state level, there is High Courts, followed by various subordinate courts which are under High Courts of that particular state. All the courts are linked with each other in a single chain. The independence of judiciary is mandated by the Constitution of India. It is kept away from all sorts of political parties or other governing bodies. For instance, the President of India appoints the judges. Also, the Indian judiciary is autonomous in its functions. The Supreme Court has the right to clarify and interpret the written constitution. The Indian judiciary is guardian of the fundamental rights and custodian of constitution. Supreme Court also has the power to review the validity of laws written in Indian Constitution. That is, the Supreme Court can reject any law that is found to be unconstitutional. High Courts also have the power to review. In fulfillment of the mission, subordinate courts are devoted to resolving civil, family, criminal and other matters fairly and efficiently in accordance with law, providing a dignified, safe and courteous environment for all people who work in the courts and those seeking justice from them. Effectively, allocating resources to implement the mandates of the legislature. Supreme Court of India and Delhi High Court. Seeking cooperation of all court personnel to further the goal of total accountability to the public. Actively integrating the court's resources with those of the community while protecting the rights of all persons regardless of race, gender, religion, caste or creed. There are two types of laws present in India, namely criminal law. Under the Indian legal system, the criminal liability for an act or omission arises out of a statute proscribing an act or omission. A breach of the statutorily proscribed act or the prescribed duty by a person is to be visited with punishment as sanctioned by the law. Thus, the criminal law connotes only the quality of such acts or omissions as are prohibited under the appropriate penal provisions by the authority of the state. It deals with the criminal dispute between organizations, individuals or between individual and organization. It deals with crime and its punishments, therefore also called as penal law. For example, sexual assault, murder, robbery, etc. Punishment includes imprisonment in jails and or monetary fine. The second type of law is the civil law. It deals with the civil disputes that is concerned with private relations between members of a community, between organizations, individuals or between individual and organization, rather than criminal, military or religious affairs. For example, divorce proceedings, property disputes, landlord or tenant disputes, etc. Punishment is mostly in the form of monetary compensation awarded to victim by the guilty party. So, hierarchy of the Indian judiciary changes according to the law. The diagram shown on screen implies the flow chart of Indian judiciary in accordance with the civil and criminal law. The hierarchy of courts that lie subordinate to high courts are referred to as the subordinate courts. It is for the state governments to enact for the creation of subordinate courts. The nomenclature of these courts or the subordinate courts differs from state to state, but broadly there is uniformity in terms of the organizational structure. Below the high courts, there are district courts for each district and has appellate jurisdiction in the district. Under the district courts, there are lower courts such as the additional district court, sub-court, municipal magistrate court, court of special judicial magistrate of second class, court of special judicial magistrate of first class, court of special municipal magistrate for Factories Act and Labour laws, etc. Below the subordinate courts at the grassroots level is the panchayat courts, which are Nyay panchayats, gram panchayats, panchayat adalats, etc. These are however not considered as courts under the purview of the criminal courts jurisdiction. District courts can take cognizance of original matters under special status. The governor, in consultation with the High Court, makes appointments pertaining to the district courts. Appointment of persons other than the district judges to the judicial service of a state is made by the governor in accordance with the rules made by him in that behalf after consultation with the High Court and the State Public Service Commission. The High Court exercises administrative control over the district courts and the courts subordinate to them in matters as posting, promotions and granting of leave to all persons belonging to the state judicial service. In each district of India, there are various types of subordinate or lower courts. They are civil courts, criminal courts and revenue courts. These courts hear civil cases, criminal cases and revenue cases respectively. Except for the Supreme Court, India has no federal judiciary like the United States. Each state has its own judiciary which administers both union and state laws. Each district in the state has its hierarchy of judicial officers, that is, munsif, civil judge, civil and sessions judge with the district judge as its head. Under this, first we have the metropolitan courts. Generally, the district judge is called as the metropolitan session judge when he is presiding over a district court in a city which is designated as a metropolitan area by the state government. Section 8 of the Code of Criminal Procedure defines that any city or town having a population of more than 1 million is considered as a metropolitan area like Mumbai, Chennai and Kolkata. These metropolitan areas have metropolitan courts. High Court of that state appoints the chief metropolitan magistrate and additional metropolitan magistrates for the metropolitan court. The power and jurisdiction of the metropolitan magistrate spreads over the entire metropolitan area. The chief metropolitan magistrate has a lower rank than a session judge does. The power of a metropolitan magistrate is given in section 29 of CRPC, which states that he or she may give imprisonment for a term not more than 3 years and a fine not more than 10,000 rupees. The District Court of India are established by the state government in India for every district or more than one district, taking into account the number of cases, population distribution in the district. These courts are under administrative control of the High Court of the state to which the district concerned belongs. Each district in a state has one district court, or depending upon the population, 2 districts can have one district court. Their jurisdiction and powers are over their particular district only. The district court is presided over by one district judge appointed by the state government. In addition to the district judge, there are many additional district judge and assistant district judge depending upon the workload. The governor of that state, with consultation of Chief Justice of India, appoints the judges for district courts. A judge is said to be a district judge when he or she officiates over the civil cases, and a session judge when he or she officiates over the criminal cases. According to CRPC, the Sessions Court has the power to impose a full range of penalties for criminal acts, including the death penalty. The Session Court has a specific classification of judges as indicated. The power of the judges increases as we go from lower to higher level. A sessions judge can pass any punishment or punishments, but in case of a death penalty, it will be subjected to confirmation by High Court only. A chief judicial magistrate can pass any sentence except death sentence, life imprisonment or imprisonment of more than 7 years. The judicial magistrate of court, that is first class, can pass any punishment of imprisonment but not more than 3 years, or fine not more than 5,000, or both. The judicial magistrate of court, that is second class, can pass any punishment of imprisonment but not more than 1 year, or fine not more than 1,000, or both. The family courts are established under the Family Court Act of 1984. The family court was set up for settlement of family disputes. The reason for enactment of the Family Courts Act was to set up a court which would deal with disputes concerning the family by adopting an approach radically different from that adopted in ordinary civil proceedings. The said act was enacted despite the fact that Order 32A of the Code of Civil Procedure was inserted by reason of the Code of Civil Procedure Amendment Act of 1976, which could not bring about any desired result. A city or town having a population of more than 1 million will have a family court. A family court deals with the following types of cases, such as nullity of marriage, declaring validity of a marriage, property cases in between families involved in marriage, guardianship or custody, etc. The judges of family court are appointed by the High Court along with consultation from the state government. Apart from judges, the family courts also have counsellors. The main function of family court is to help the parties for settling their matters with respect to the subject of case. Family courts also have medical and welfare experts. One of the most peculiar things about family courts is that they can make their own procedures according to different cases. The next type of courts are the labor courts and industrial tribunals. The law relating to labor and employment in India is primarily known under the comprehensive category of industrial law. Industrial law in this country is of recent vintage and has developed in respect to the vastly increased awakening of the workers of their rights, particularly after the advent of independence. Industrial relations embrace a complex of relationships between the workers, employers and government, basically concerned with the determination of the terms of employment and conditions of labor of the workers. A labor court is concerned with disputes between employees and employers as mentioned in Industrial Disputes Act. The Industrial Dispute Act of 1947 imparts the protocol for managing the rights of employees and employers and provides aid for settling issues in a harmonious manner. The state government establishes the labor court. A labour court usually has one judge appointed by the state government. He or she will be called as the chairman, or it may also have more than one judge. Next here we will be discussing about the tribunals. Tribunals are the independent body not included in the typical hierarchy of Indian judiciary. Tribunals are established for special types of disputes. They are the part of alternate dispute resolution mechanism, or the ADRs. The basic difference between tribunals and courts is that the courts are driven by laws mentioned in CRPC, IPC and IEA, but in case of tribunals, they follow their own laws created by that particular type of tribunal. Presently, the tribunals occupy an important part in the sphere of adjudication of disputes. The tribunals have original jurisdiction over many matters. The Administrative Tribunals Act of 1985 was enacted by Parliament in pursuance of Article 323A of the Constitution of India. The jurisdiction and power to decide disputes and complaints with respect to recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the Union or of any state, as also any local or other authority, is brought within the exclusive jurisdiction of the central or the state administrative tribunal, as the case may be. The Act provides for the exclusion of jurisdiction of all courts except the Supreme Court with respect to disputes or complaints in service matters. As a result, in respect of matters which fall within the jurisdiction of the Administrative Tribunal, the jurisdiction of the High Court stands excluded. Article 323A of Constitution of India of 1950 reads, Administrative Tribunals. Parliament may by law provide for the adjudication or trial by administrative tribunals of disputes and complaints with respect to recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the Union or of any state or of any local or other authority within the territory of India or under the control of the Government of India or of any corporation owned or controlled by the government. Second, a law made under clause 1 may provide for the establishment of an administrative tribunal for the Union and a separate administrative tribunal for each state or for two or more states, specify the jurisdiction, powers including the power to punish for contempt and authority which may be exercised by each of the said tribunals. Provide for the procedure including provisions as to limitation and rules of evidence to be followed by the said tribunals. Exclude the jurisdiction of all courts except the jurisdiction of the Supreme Court under Article 136 with respect to the disputes or complaints referred to in clause 1. Provide for the transfer to each such administrative tribunal of any cases pending before any court or other authority immediately before the establishment of such tribunal as would have been within the jurisdiction of such tribunal if the causes of action on which such suits or proceedings are based had arisen after such establishment. Repeal or amend any order made by the President under clause 3 of Article 371D. Contain such supplemental, incidental and consequential provisions, including provisions as to fees, as Parliament may deem necessary for the effective functioning of and for the speedy disposal of cases by the enforcement of the orders of such tribunals. Third, the provisions of this article shall have effect notwithstanding anything in any other provision of this Constitution or in any other law for the time being in force. Similarly, Article 323B of the Constitution of India 1950 reads, Tribunals for other matters. First, the appropriate legislature may by law provide for the adjudication or trial by tribunals of any disputes, complaints or offences with respect to all or any of the matters is specified in clause 2 with respect to which such legislature has power to make laws. Second, the matters referred to in clause 1 are the following, namely, levy, assessment, collection and enforcement of any tax, foreign exchange, import and export across customs frontiers, industrial and labour disputes, land reforms by way of acquisition by the state of any estate as defined in Article 31A or of any rights therein, or the extinguishment or modification of any such rights, or by way of sealing on agricultural land or in any other way, sealing on urban property, elections to either House of Parliament or the House or either House of the Legislature of a state, but excluding the matters referred to in Article 329 and Article 329A. Production, procurement, supply and distribution of foodstuffs including edible oilseeds and oils and such other goods as the President may by public notification declare to be essential goods for the purpose of this article and control of prices of such goods. Offences against laws with respect to any of the matters specified in subclause A to G and fees in respect of any of those matters. Any matter incidental to any of the matters specified in subclause A to H. The different types of tribunals present in India are: first is the appellate tribunal for electricity, that is ATE, Armed Force Tribunal, Central Electricity Regulatory Commission or CERC, Central Administrative Tribunal or CAT, Company Law Board, Competition Commission of India, that is CCI, Competition Appellate Tribunal, Copyright Board, Customs, Excise and Service Tax Appellate Tribunal, Cyber Appellate Tribunal, Employees Provident Fund Appellate Tribunal, Income Tax Appellate Tribunal, Insurance Regulatory and Development Authority, that is IRDA, Intellectual Property Appellate Board, National Green Tribunal, Securities and Exchange Board of India, that is SEBI, Telecom Disputes Settlement and Appellate Tribunal TDSAT, Telecom Regulatory Authority of India TRAI. The powers of tribunals are same as those of a civil court, like issuing of summons, witness examination, passing interim orders and issuing commissions. Further, the judgment passed by tribunals can be appealed in high courts. Tribunals function differently from courts, from the manner of appointment to the procedure followed, yet they seek to achieve the same objective as that of courts, that is, to deliver justice. In this slide, the paper proceeds to analyze the tribunal system in India. The Indian judicial system is one of the oldest legal systems in the world. It is part of the tradition of India received from the British after more than 200 years of their colonial rule. The framework of the current legal system has been laid down by the Indian Constitution, and the judicial system derives its powers from it. There are various levels of judiciary in India comprising different types of courts, each with varying powers depending on the tier and the jurisdiction bestowed upon them. They form a hierarchy of importance in line with the order of courts in which they sit, with the Supreme Court of India at the top, followed by the high courts of respective states, with district judges sitting in district courts and magistrates of second class and civil judge, that is junior division, at the bottom. By gearing law to changing customs, Indian jurisprudence gave the concept of law a secular content. Moreover, it developed the evolutionary concept of law and rejected the concept of an absolute, eternal, never-changing law. Indian judiciary is so vast that every court has its own discrete powers. Power increases with each level. In India, there are more than 600 district courts. The pendency of cases is increasing day by day majorly due to lack of judges and availability in courts in Indian judiciary. The bulk amount of case is dealt by the subordinate courts. The judgment passed from the subordinate courts can be appealed in higher courts. Depending upon the area and the population, the city or town gets the tag of metropolitan area and have its own metropolitan courts or city courts. The power given to the judges varies from their positions, like Chief Judicial Magistrate have more powers than a first class or second class magistrate, etc. Now, this is time for your self-study. If you want to learn more for enhancing your knowledge, you may log on to our website www.cec.nic.in for assignments, MCQs, quizzes and LORs and other materials. Till then, keep studying and goodbye.